SJC-11923, Linda S. Bowers v. P. Wile's, Inc.
Good morning, Mr. Black. Give us a moment.
Yes, sir.
All right, you may proceed.
Good morning, may it please the court. My name is Joseph Black, and I represent the defendant, P. Wile's, doing business as Agway of Cape Cod. Your Honors, we are here before you today to address two questions. Whether or not this case finds itself within the narrow subset of premises liability cases in which the mode of operation approach is applied, and we suggest it is not. And then secondly, regardless of whether the mode of operation approach applies, should the summary judgment be reinstated because the evidence of Agway's reasonable measures went unchallenged, and we submit that it should. From a procedural standpoint, this began as a motion for summary judgment in the Superior Court, in which Agway's was granted summary judgment for two reasons. One, the mode of operation was inapplicable, and two, that in any event, there were reasonable measures that were undertaken by Agway, and the court found that no matter whether the mode of operation would apply or not, that summary judgment was appropriate. There was a motion for reconsideration. The court then upheld and denied the motion for reconsideration. The plaintiff then appealed to the appeals court, and in a 2-to-1 decision, the court reversed, held that the mode of operation was applicable, and said that the reasonable measures that were argued below were a jury question. We then sought further appellate review, and we're here before you today as a result. Factually, on December 28th, 2011, Mrs. Bowers and her father had pulled into the Agway. This Agway is located in Orleans. There's 3 of them. This is a 4,000 square foot location with a 7,000 square foot warehouse behind. Agway sells home products, garden goods, and pet supplies. And that day, there were 5 employees who were working within the store. Mrs. Bowers got out of her car, started to walk down a sidewalk, and felt an uneven surface underfoot. When she fell and she was assisted, she said, pointed to a 3/4-inch pebble stone, a river stone, and said that's what was the cause of her fall. Off to the right of that sidewalk area is a area of about another 6 foot wide, which is filled with these pebble stones. So it's a permeable area. And then beyond that is another 6 to 8 foot concrete sidewalk that goes up to the building. From the building, there's a roof that hangs down.
But it is the case that I don't know about December 28th, but it is the case that customers of Agway would walk in that pebbled area looking at bird baths or whatever else might be offered for sale in that area, isn't that?
Or for if there was nothing there, may traverse it. Absolutely, Your Honor. So a product would be displayed depending upon the season, summer, spring. The winter is the slowest. This was the slowest time of the year, and particularly the week between Christmas and New Year's. This is December 28th. There were 3 Boulder bird baths that were seated or in this area at the time.
Let me get you straight to the issue of law, if we can.
Sure.
Why should mode of operation be limited to spillage or breakage, and not include foreseeable dangers?
I think it can include foreseeable dangers. The issue is that, and there's at least one of the cases cited that it had to do with I think it was in a Walmart where a fellow was trying to help himself, but they fell off above from him. So it's not a spillage necessarily or breakage, but there are various circumstances that when it can occur. However, in this circumstance, it's very different. First of all, the court has held this notion of mode of operation to apply very narrowly.
Well, that's the question. Why apply it so narrowly? Why not simply say that mode of operation is simply one means by which an owner of property must recognize a foreseeable danger, whether it be from grapes or fruit being mishandled, or of spillage of drinks on a dance floor? Why can we not say, well, the recognition that pebbles on a walkway are a foreseeable danger, and owner must take reasonable steps to avert that foreseeable danger?
For several reasons, in this case in particular. One, that pebble, that 3/4-inch river stone, we don't know where it came from. We don't know how it got there. It may or may not be, well, we don't know the reasons or the
Wait,
circumstances that it got there.
But you're not questioning whether, are you saying it isn't similar to the ones that were in that area?
No, we're saying it's similar to the ones
I
that
mean,
are in that area.
it came from that, you just don't know how it got onto the walkway, but it's not, you don't dispute that it came from that area,
We
right?
don't dispute it came from that area. It's certainly one that perhaps came out in some fashion. We just don't know the fashion which it came out, which
And
is the
weren't there
traditional
steps
notion is
taken to clear this away? I mean, periodically to, I thought that there was a recognition that sometimes they got onto the sidewalk or onto the walkway.
they have a procedure in place.
So they know it happens.
They are aware that the pebbles will leak out on
Does that make
occasion.
that foreseeable and a danger?
It may not in this particular circumstance of applying a mode of operation. Doesn't in the context of the, the tort lawyers traditionally look in the traditional notion, there are issues as to taking a total look at what has occurred. That is, the likelihood of injury, or the severity of injury, the likelihood of the event occurring. I think in the traditional notion, there's enough there to evaluate what this particular store did on that particular occasion to apply that. But from a foreseeability standpoint, in this case, it would not make sense, I suggest, because first of all, you don't know where the pebble came from. Secondly, this is not necessarily associated with a particular mode of operation. There's no more. It's a
condition.
It's an exterior
It's
design.
not, but I mean, I take it what you're saying is, look, this gravel is there because the municipality requires certain drainage things. There's a concrete walkway. The fact that there's gravel there is not part of the mode of operation, but you do have your products present on the gravel. The question is whether that becomes a mode of operation then.
Right. Does the mode of operation apply in such a broad sense? And we say that it doesn't. It's got to be far narrower,
but I guess-
like the Sarkissian case.
But my question is broader. My question is, why are we limiting ourselves to mode of operation? Why should the framework be mode of operation as to a foreseeable danger? Whether the foreseeable danger be that there's a foreseeable danger that people may be kicking gravel stones onto a walkway and people could trip, or the foreseeable danger being that on a rainy day, people are going to bring in wet umbrellas and there's going to be slipperiness at the entrance. Why must the foreseeable danger be limited only to those within the mode of operation for it to trigger a duty to take reasonable care?
The two cases that this court has decided, both Sheen and Sarkissian, are very clear in terms of the mode of operation, that there are limits to apply to this. It's just, in Sarkissian, there was no problem with someone walking around with a drink itself. It was the limited circumstances in which it was foreseeable that someone was going to be knocked around with the dancing and the dark floor. And the court went through a lot of trouble to talk about
So why isn't it foreseeable here that would happen?
foreseeable in terms of a stone being knocked
Yeah.
out, because this is not connected. There's no evidence that it's as a result of third-party interference during a mode of operation. If we're to just look at it simply as the riverbed is the problem, then you're taking away the traditional notion. This can be evaluated as a traditional approach case. And it actually was, and that's what the Superior Court judge did. He made his decision based on the
Yes,
fact
but
that
that's a note, but then you get into notice, right? That's a sort of Oliveri question.
whether you have actual constructive notice, correct. And in this circumstance, why would that be any different? If you just take the riverbed alone and those stones can come out, this is not an unusual, it's not a particularly unique circumstance for river stones to be on a ground, or loose brick to be on a ground, or some other, or the mulch that we're talking about that somehow would be affected. Those aren't so unusual or unique to invoke the mode of operation rule, and particularly in this case. And that's, I think, where we're at.
If we, just hypothetically, if we were to disagree with you, what's the measure that merchants will take? I mean, do they have to put macadam over every square inch of their surface, or do they have to send people out to brush stones away? off the path? They have to do it every 15 minutes?
The impact would be huge. They would have to under this circumstance, those permeable stones were put in because they really only a couple choices. The municipality required that it be permeable, so it could either be sod, some sort of grass, or it could have been the stones themselves. In order to address, I mean, there's plenty of these locations where those stones are out as part of a parking lot. Seashells that are crushed. I mean, there's a number of circumstances that will require tremendous burden on the commercial entities to guard against what should be evaluated under the traditional notion. And the elements are there in this case to have that evaluated. And in fact, the Superior Court judge did that.
But the burden would only be reasonable care, which you say you satisfied.
The reasonable care would be the burden, correct?
And then that's what a property owner owns, an invited guest, right?
Is a duty of reasonable care, correct? But not
I mean, I'm a little bit confused. You're saying this would be, if we were to expand the mode of operation to include foreseeable dangers, it would be a terrible burden. And then you go on to say this particular owner already was taking reasonable steps to avert that very same risk, and that was a reasonable course of action here, and therefore there should be no liability.
The expansion that we're talking about right now would be enormous. It would be I think, a supplanting of the traditional notion. You would no longer have the traditional notion. You just have to go to whether or not it was a foreseeable event, any foreseeable event.
And that would give you the notice prong. You still would have to show reasonable, the lack of reasonable care doesn't change that.
But why, under the context, should a commercial entity be placed in a circumstance different from other negligence evaluations when, in fact, they have done what's reasonable under the circumstances to address, but in the court going in the direction that we're talking about right now is removing all limits to the mode of operation, which this court took time and effort to make very clear that in the Sarkissian case that there were limits and that there were clear limits to the mode of operation. This would expand it so wide it would be very difficult for
Let me
a
ask you this.
commercial entity.
What if you didn't have, they didn't have anybody who periodically went and checked and knocked pebbles back? They just did nothing. I mean, they just considered pebbles are pebbles and people need to look where they are. And actually somebody fell and brought an action. Would you say would that be relevant at all, that you do absolutely nothing about it because you don't know when that particular, would you win because she couldn't show when that particular pebble came onto the walkway?
She would be able to demonstrate that there was a lack of any procedure. Perhaps she might have to put an expert in. Maybe she'll have some sort of evidence in terms of how these pebbles can.
What does she do about the
migrate.
notice problem?
Whether or not there's actual constructive notice in terms of the fact that you can depose certain witnesses from the store. Do these pebbles come out? Do they come out on occasion? Of course. That evidence would be able to be flushed out, and you're still back at the situation of evaluating this case in the traditional notion.
So you're saying then that the notice requirement is met by proof that this is a recurring and foreseeable danger?
It could be.
The notice.
You're saying that the notice is met if you could show that there is a recurring and foreseeable risk that pebbles will be on the walkway, even if you had no clue that there was a pebble on the walkway at 3 o'clock on this day.
Well, I think the hypothetical is whether or not, how would you go about proving that case in either the actual or constructive notice? I'm just suggesting it's possible to proceed under that fashion. It's
Right, but I'm trying to understand what you understand the notice requirement to be with regard to the constructive notice. What is your understanding as to when you met the standard for constructive notice? Assuming you had no knowledge that there was a pebble on the walkway at that moment in time.
The landowner had no knowledge that there was a pebble on the stone at the time. There was no actual knowledge that could be proven. It could have then been proven by the number of, just as in the line of Oliveri cases, the proximity of employees to the area, the fact that the stones are permeable and that they move, the fact that there have been occasions, perhaps from other witnesses who have walked in the area. Her prior times that she's been there, she's seen stones on the walkway. There are a number of ways of getting to the issue of constructive notice, and which would satisfy the burden. So I think if we go in the direction of removing any sort of parameters to the mode of operation, it's going to supplant the traditional notion, and that won't exist. I did want to point out that at least with respect to the second argument in the Superior Court, that the judge found that in any event, whether you apply the mode of operation or not, that there was evidence put forth that there were reasonable measures by Agway to address the issue. And they did that by having their employees come out. They would check on a regular basis, that when they were out there, they were required to put items back in place, to kick any stones back in that they may see. And that one employee, Mr. Bowman, had testified he did that every 15 minutes. He was asked 3 times, how often do you do this? Do you follow the policy? Yes, I do. I go out every 15 minutes. Do you do it on a regular, continuous basis? Yes, I do. And do you do it, is it ingrained? The question was, is it ingrained in your daily business, the way that you do it? And the answer to that was, yes, it's ingrained in my daily business.
But if he's at the cash register, how does he, wasn't that the problem here? Wasn't he at the cash register that day?
Well, at the moment in time, he's at the cash register.
Oh, I see.
But the evidence suggests that, the habit, that there was evidence of business habit. And there was no countervailing evidence whatsoever. And Corus Civilis says that under that scenario, summary judgment should be allowed, and the Superior Court judge got it right.
So you're saying that business habit is sufficient even if there's no evidence that the habit was actually carried out that day?
The case of Palinkis versus Bennett supports that, Your Honor, that exactly. In Palinkis versus Bennett, the doctor had informed his patients that on a premature baby, they have to be aware of infections. And he could not recall giving that instruction on the day that they were released from the hospital, but it went into evidence as that, in fact, he conformed with his habit, and that was allowed.
Okay, thank you.
Great, thank you very much.
Good morning, Justices. May it please the Court, David McCormick for the appellant, Linda Bowers.
Mr. McCormick, let's assume for a moment, I got the photo right in front of me. You've got the gravel, the permeable surface in between 2 concrete walks. Let's assume for a moment that the store didn't put a couple of bird baths in the gravel. Traditional liability analysis apply?
I believe so, Your Honor.
So it's the fact that the store put some products there that could be observed by customers walking by into the store that makes this mode of operation?
That's our position, Your Honor. As it's stated in Sarkeesian, what the store did was it created this gravel strip, knew that people walking on the gravel strip would result in stones being on walkways, and that it presented a trip and fall hazard. Knowing that, rather than discouraging people from walking onto or through this gravel strip, it actually encouraged that activity by displaying items on that gravel strip with the knowledge that people would walk onto, would walk through it, whether to take items or even just to inspect items. And it knew that there was a trip and fall hazard that resulted from that. And that's what happened on December 28th. The inevitable happened. Ms. Bowers stepped on one of those stones. Now, whether...
Now, how long had this condition existed?
I believe, Your Honor, the evidence is that it was constructed in either the 80s or the 90s, excuse me, it had existed for, I will say it existed for well over 10 years, Your Honor.
Anyone else fall on a stone on the walkway?
No, Your Honor.
Okay.
That
Wasn't much of a hazard then, I guess.
Well, it was enough of a hazard, Your Honor, that the store knew about it, and they had this informal policy of having the employees go out and look at the walkway, and that's
Well,
one
that
of
makes
the-
sense. That's sensible, to keep the walkways clear. That's
Correct.
sensible under any circumstances, not just these. Let's assume there were no bird baths in the middle there. It still would be sensible for the store to periodically ensure that the walkway was clear,
Correct, Your Honor.
okay? Right?
The question is whether or not they did that. And the evidence of the reasonable, if we're talking about what reasonable measures the store took, the facts of this case are similar to Sarkeesian, where the employees of the bar knew about drinks being spilled on the dance floor on a regular basis. They sometimes went out and would clean up spills, but there was no formal policy for doing so. There was no written policy setting forth what time employees or how often employees were
In
supposed to do that.
Sarkeesian, these are products being sold right there that are being consumed right there and
Correct,
spilled right there.
correct.
So these are the products that are causing the problem.
That is
Customers' use of the products in the facility.
correct. And I understand that that is a distinction that Agway or P. Wiley's is trying to make in this case, that because the stone itself was not an item for sale, that the mode of operation should somehow not apply. And I would point to the and the argument is that if we limit the mode of operation to only items that are for sale, we're going to end up with very inconsistent or illogical results. In the example that we had set forth before the appeals court, which they picked up on in their brief, was the example of using the grapes from Sheehan, the grapes being stored on a bed of ice, customers being invited to help themselves to the grapes, ice falling to the ground and creating a slip and fall hazard. It would be illogical to say that the mode of operation should not apply because the item that caused the injury was not for sale or was not, the public was not invited to carry that item throughout the store.
Well, does it make any difference that that in the mode of operation cases that we've had so far, the substance that's on the floor is something that is not normally on the floor. It's not expected to be on the floor. Whereas here, these are stones that were on the ground. You expect stones to be on the ground.
I would argue that you don't expect them to be on the walkway.
Well, what if they had poured stones all over the walkway?
If they had poured stones
Stones all over the walkway.
It's a gravel walkway.
Well, I think that's a little bit different. If it's a gravel walkway, you know that you're walking on a gravel walkway. This was a walkway, the gravel strip here bisected the only walkway that a customer can use to enter the store, okay? And I think there is a difference between a gravel walkway and there being a stone that is a raised surface that is admitted by the defendant that it is a trip and fall hazard that it knew about. The defendant admits that that was a reasonably foreseeable event, and the inevitable happened here.
Now, your brother says even if you get past the mode of operation, you still lose because you have evidence of business habit and no evidence to the contrary.
Yes.
Why is that not true?
That's not true because if you read Mr. Bowman's testimony, what he said was, yes, he had a regular practice that when he would go out to customers' cars, he would check the walkway for stones. This was not a regular day, however, for him. His testimony, and it's set forth in the appeals court decision, but his testimony is that he was at the cash register that day with a steady stream of customers. The reasonable inference to be drawn from that is that he was not going out and checking the walkways. This was not a typical day, as Mr. Black alluded to. This was not a typical day at the store. There was instead of 7 to 10 employees, there were only 5 employees there that day. And 2 of those employees were out on a delivery. So there's 3 employees in the store. There's Mr. Bowman, there's Miss Wiley, and there's someone in the warehouse. Mr. Bowman and Miss Wiley are both at the cash registers. That's the testimony in this case, and there's someone in the warehouse. So who was it that day that was going out onto the walkway and inspecting it for stones? There's a reasonable inference here that no one was doing it that day because the way of the store was staffed that way that day, and because there were people that were out on delivery. In addition to that, as I alluded to earlier, the question of whether all reasonable precautions have been taken is one for the jury to decide. And we have a business policy here that's informal, it's not written down. The store, this is in Miss Wiley's testimony, the store had a checklist, a safety checklist for cleaning within the store. There was no such checklist for anything outside the store. So I think the setting aside what Mr. Bowman's business habit was, I believe the inference is he didn't follow it that day. And absent Mr. Bowman doing this job on December 28th, there's no evidence that anyone else did it.
But of course, you bear the burden of proving the absence of reasonable care.
Correct, Your Honor.
So are you saying, and that they will present evidence that this was their business custom, and you think it's sufficient to say it is possible that that business custom was not followed on this day is going to be sufficient for you to establish negligence?
Well, yes, Your Honor. And I think there's actually a twofold question here for the jury about whether reasonable precautions were taken. Number one, it's whether this informal policy, just like in Sarkeesian, with no set times, no person who was assigned to do this job, whether this informal policy itself was reasonable. There's also the question of, even if the jury finds that what the defendant had in place as far as checking for stones on the walkway, even if the jury finds that this informal policy was reasonable, there's still enough evidence submitted for a jury to find that the policy was not followed on the day in question. And I think what has been presented is certainly enough for the plaintiff to get to a jury and have the jury decide whether or not the defendant was negligent.
Yeah. You know, a lot of people have stone driveways that come up to sidewalks, and the stones from the driveways invariably end up on the sidewalk. I'm wondering where this takes us, where this case takes us. Are people going to be liable because they didn't sweep the stones off the sidewalk back onto their driveways?
Well, I think that's a very big distinction. You have here a business owner who is inviting the public onto its property for the purpose of selling goods and making money. And business owners under those circumstances are held to a much higher standard with respect to the care that they have to provide to business invitees on the property. So under these facts with a business owner, I think it's certainly reasonable to hold them to that standard. With respect to a homeowner or a home property owner, the question of whether or not the property owner took all reasonable measures would be a much different analysis, I believe.
But if this were, I mean, if this were simply a gravel walkway, that's all. Just it's the walkway that was gravel, not concrete. So you would apply mode of operation to the fact that they have a gravel walkway as
No.
an exterior element of their design as opposed to something else? Stones might be dangerous at any time?
No, Your Honor. I think if it was a gravel walkway, there would be a different analysis. It's basically, it's the duty of reasonable care, and whether or not the gravel walkway in itself was inherently defective, if it's a normal, level gravel walkway.
Yeah, and with products along the way, as you're walking into the store, there are bird baths on the right, right?
Okay.
So that would not be mode of operation, that would be traditional liability theory.
I believe so. Whether it's a gravel walkway or just a paved area, I don't really think it would matter. The issue is here is you have customer interference with this gravel strip that creates a dangerous condition on the walkway. The defendant knew about it, and I think under the facts here in this particular case, that satisfies the mode of operation analysis.
And in terms of determining what's a dangerous condition, is that an issue of law or issue of fact? I mean, you would have to establish it was a dangerous condition. Court has appeared to say that a slippery floor is a dangerous condition, but is a piece of gravel on a walkway a dangerous condition?
Yes, Your Honor, and that has been admitted in this case, that the stones on the walkway represented a trip and fall hazard to customers, that the defendant was aware that it needed to take some measures to prevent against an accident from happening. So in this case, that's admitted.
Admitted because they took steps to avert it? Is that admissible against them?
Well,
I mean, are those reasons? I mean, if they take affirmative steps to prevent something, can that then be used against them and to say, aha, you knew of that danger?
well, it's not only the fact that they took preventative steps or proactive and some sort of proactive measure, it's the fact that the 30B6 deponent admitted that stones on the walkway created a trip and fall hazard for its customers.
So it's a verbally articulated admission. It's not just an inference that you're drawing.
Correct, Your Honor, and it's also in the statement of facts that was admitted to at the trial court level.
Okay, thank you.
Thank you.